other day in the hallway. You're singing, "Oh Happy Day."
Good morning, ladies and gentlemen. Thank you. I see everybody right here safely. We're going to continue with the case. Cross-examination. Mr. Hughes. And Mr. Hughes, I will remind you that you're still
I understand.
The state's exhibit 66 up there on the overhead. Mr. Hughes, when you dragged Christina Parcell across the floor of the front room where you killed her, did you drag her by her arm or by her ankle?
I don't remember for certain, but I think by the ankle.
That's all the questions I need to ask this, Your Honor.
Any limited redirect?
No redirect, Your Honor.
Mr. Hughes, you can start. Any other witness? Defense going to call any other witnesses?
Your Honor,
And I am aware that you wanted to put additional proffer.
yes, not at this time.
Okay. All right. Ladies and gentlemen, I'm going to ask you to go back to your jury room, and I'm going to be taking up a few matters, hopefully very quickly, and we'll be back with you. Good morning, ladies and gentlemen.
Good morning.
Thank you. I see everybody right here safely. We're going to continue with the case. Cross-examination. Mr. Hughes. And Mr. Hughes, I will remind you that you're still correct.
I understand, Your Honor.
And it states Exhibit 66 up there on the overhead. Mr. Hughes, when you dragged Christina Parcell across the floor of the front room where you killed her, did you drag her by her arm or by her ankle?
I don't remember for certain, but I think by the ankle.
That's all the questions I need to ask this, Your Honor.
Any limited redirect?
No redirect, Your Honor.
Mr. Hughes, you can start. Any other witness? Defense going to call any other witnesses?
Your Honor,
And I am aware that you wanted to put additional proffer, but
yes, not at this time.
okay. All right. Ladies and gentlemen, I'm going to ask you to go back to your jury room, and I'm going to be taking up a few matters, hopefully very quickly, and we'll be back with you. Welcome back. Just be patient and understand there are procedures that have to go in, and I'm sorry that I have to send y'all in and out, okay? All right, anything further?
Nothing further, the defense rests.
Defense rest. Okay, ladies and gentlemen, you can go back to the jury room.
Please state your name for the record.
Zachary David Hughes.
Zach, how old are you?
I'm 32 years old.
Are you married?
No.
Do you have any brothers or sisters?
Yes, I do.
Tell this jury about your brothers and sisters.
I have 5 brothers and sisters. One is my biological brother, Eli, and the rest are my adopted siblings.
At one point, did you have 6 siblings?
Yes, I did.
Talk about that in a minute. Where were you born?
I was born in San Luis Obispo, California.
Did you grow up in the entirety of your childhood in California?
No, I did not.
From California, where did you and your family move?
We moved to Southwest Virginia when I was 11.
While you were still living in California, did you discover that you had an aptitude for music?
Yes, I did.
What, if anything, did your mom or dad do by way of an instrument to help you learn how to play music?
When I was maybe 4 or 5, my dad found an old Gulbranson upright piano at a yard sale, and he bought it for, I think, $300 and rolled it down the street to our house. So I had an instrument to tinker on when I was young, even before I started piano lessons.
Describe, just in general to this jury, what was your, while you were in California and early on in Virginia, what was your home life like? What was it like to grow up in your house?
I had a great childhood. I have great parents. They raised my biological brother and I before we adopted in a Christian household. They taught us good values, the importance of good morals and service to others, and they supported me in every way imaginable, and I'm very grateful for them.
And Zach, you may want to back up just a little bit from the microphone. I think you're getting just a little bit.
Okay.
Yeah, that's a little bit better. Thanks. Describe for the jury, you talked about your Christian values in the household. Describe for the jury sort of the, early on at least, the connection between your parents supporting you playing music and the Christian dynamic in your family.
Yeah, originally when I was 9, my parents started me on piano lessons. Our pastor's daughter taught piano lessons, and my dad wanted me to play hymns and family devotions.
You testified earlier that you and your family moved to Virginia. Tell this jury where you and your family moved in Virginia.
It was a town called Abingdon. It's right next to Bristol, Virginia, which is known for the NASCAR Speedway.
Describe to the jury what your family's residence was like. Where did you live, and sort of describe that dynamic.
We moved to a small 3.5-acre farm. My parents liked the idea of raising some farm animals and giving my brother and I the opportunity to do physical work on a farm, and just the opportunity to be close to nature and grow up understanding the value of hard work.
In 2005, did your family grow beyond just you and your brother and your parents?
Yes.
Describe for the jury how your family grew in 2005.
The church we were a part of at a time really encouraged adoption, especially for families or couples who weren't able to have kids at that point in their life or at all. And as a result of this belief in the church that it was good to adopt, there were emails that would be passed around occasionally, and there was an email that was passed around with a photo of 5 Russian siblings who were up for adoption in Russia. And my family saw these photos, and our heart really went out to these kids. At first, we thought they were all boys because their heads were all shaven for lice, and they were all wearing sort of the same kind of clothes, hand-me-downs. But they were 3 girls and 2 boys. And after a lot of prayer and thought and discussion about it, we decided we wanted to adopt these kids because essentially if we didn't, who would?
So, just briefly, let's talk about these kids. How old was the oldest child at the time your parents adopted them?
She was 10.
What was her name?
Her Russian name was Yelena, but we gave all the kids American names, so her name was Grace when we adopted her.
So Grace was 10. How old was the youngest?
18 months.
We're going to come back to them in just a little bit. At some point, did you and your family move to South Carolina from Virginia?
Yes.
How old were you when your family moved to South Carolina from Virginia?
I believe I was either 15 or 16.
Where did you and your family move in South Carolina?
We moved to Travelers Rest in Greenville County.
During this time, describe for the jury what is going on in your music progression, your life as a musician, and how you're progressing.
Like I said, I started piano at 9, and when we moved to Virginia, I became increasingly more interested and motivated in it. So by the time I was, say, 14, 15, I was practicing on average 6 to 8 hours a day. We were homeschooled, so this allowed me to do this. And by the time we had moved to Travelers Rest, I was very convinced that I wanted to pursue music as a career.
You testified you were practicing a lot. During this time, did your father do anything to provide the rest of the family some peace while you were practicing so much?
Yes, I like to practice late into the night and into the early morning hours, so my dad actually built me a soundproofed room out in the garage so I could do this without waking the neighbors.
So as your musical capabilities improved and increased, while you were in high school, did you participate in any music festivals, specifically regional music festivals?
Yes, many.
Did you ever win a prestigious regional music festival?
Yes, several.
All right. Describe to the jury what opportunity you were given in connection with the South Carolina Philharmonic Orchestra.
In 2011, I participated in a high school piano festival in Columbia, South Carolina at the University of South Carolina called the Southeastern Piano Festival. And part of this festival, there was an international concerto competition. A concerto is a piece for a solo instrument and orchestra, so in this case, solo piano with orchestra. And that was the Arthur Fraser International Piano Competition, and I was awarded first prize. And part of first prize was the opportunity at a later date to perform a full concerto with the South Carolina Philharmonic. And maybe a year later, we did Beethoven's Emperor Concerto.
You testified about high school and your progression as a musician in high school. I want to talk about college. When it came to go for you to go to college, where did you apply to go to college?
I applied to 5 different conservatories in the country.
Were you accepted to any of those conservatories?
I was accepted to 3.
Where did you decide to go to college?
I went to the Juilliard School in Manhattan.
The year you applied, what percentage of applicants were granted admission to Juilliard?
I believe it was 7.2%.
And you were one of those musicians.
Yes.
When you were accepted, what, if any, inducements or incentives did Juilliard give you to attend their institution?
They offered me a generous financial aid package and a merit-based scholarship.
When did you begin your education at the Juilliard School?
I matriculated in the fall of 2011.
I want to talk about what you did while you were there. While you were at Juilliard, did you have an opportunity to participate in an international music festival?
Yes, I did.
Please tell the jury about that.
There is an international music students festival in Kyoto, Japan, which is called I think the Rome Music Foundation sets it up, and they try to get music students from all over the world, from different countries. So they get a sampling of different countries, and they have a relationship with Juilliard. So an email was sent out to the student body asking if anyone wanted to participate, and I was selected to represent the states in Kyoto for this festival.
And so how many students from around the world participated in this festival?
Maybe 15 to 20.
And how many from America were selected to participate?
One.
And that was just you.
Yes.
Did you graduate from the Juilliard School?
Yes, I did.
When did you graduate?
In May of 2015.
And what was the degree you obtained upon graduation?
A bachelor's of music and piano performance.
Just briefly describe to the jury, after you graduated, what did you do in the music field for employment immediately upon graduation?
I did what a lot of conservatory graduates do who decide not to immediately pursue a higher degree. I did a lot of freelancing. I did some solo gigs, playing concerts. I did some accompanying. I taught some students. And I even took on some work in restaurants to supplement my income.
At some point, were you given the opportunity to be on staff with the Knoxville Symphony?
Yes, I was.
When did you receive, or when was that opportunity given to you?
I heard about the audition, that I heard that a spot had opened up for principal keyboardist in the Knoxville Symphony, and I heard about it 3 days beforehand. So last minute, I learned a bunch of excerpts and auditioned, and I was fortunate enough to get the job in 2017.
You talked about the principal pianist. Tell the jury what the principal pianist, what that title means and what your function was.
It is a principal keyboardist, so it's basically any instrument part in the orchestra that has a keyboard I would be playing. So it could be piano, harpsichord, synthesizer, celesta.
When did you begin your employment as the principal pianist for the Knoxville Symphony?
In 2017.
When did your employment end with the Knoxville Symphony?
In 2018.
What did you decide to do in 2018 that required you to leave the orchestra? Or the symphony, rather, I apologize.
I decided to enlist with the Marine Corps.
So, you're a classically trained pianist. You have an opportunity with a symphony to perform with them, which is regular employment, and you decide to leave that and go serve your country in the Marine Corps. Is that correct?
Yes.
Describe to the jury why you decided to leave your job with the symphony to serve your country in the Marine Corps.
Since about my sophomore year of college, it had been something I'd been thinking about, military service. And obviously there's a window of time that you're able to do that in as you get older. You hit age limits and so forth. And it had just always been something I was interested in, the service of others, service to others aspect of it. I felt like, in a sense, I owed a debt to my country and to do some military service. And I also wanted the opportunity to experience a difficult training environment. And I figured the Marines they had a reputation of being the hardest, so that's the branch I decided to go for.
What, if any, attributes of your childhood or the home environment as you grew up, what, if any, of those attributes played into your desire to join the Marine Corps?
I think the way my parents had always instilled in us a good work ethic and an important sense of just a moral duty to others, it seemed like a very good opportunity for me to further develop some of these things in myself.
You testified that initially you enlisted in the Marine Corps. Ultimately, did your journey continue as an enlisted person in the Marine Corps?
No.
Why not? Tell this story.
I was speaking with my recruiter, and they ask you a lot of questions, just trying to figure out who you are and what aptitude you might have for different aspects of the service you're going for. And he found out that I had a college degree, which meant, unbeknownst to me, that I was eligible for officer candidates. Found that out, they tried to funnel me into, it's a different recruiting program, but they got me in touch with the officer selection officer and encouraged me to go the officer route.
During the selection process for officer candidate school, were you living in Tennessee at the time?
Yes, I was.
And briefly, if you would, describe for the jury during that period in Tennessee what the process was that was used for officer candidate school, or OCS, for selection.
It's a little different than recruiting. You have to go through a pretty rigorous selection process to even be invited to OCS, so you spend a lot of time with your OSO, or your officer selection officer, and it's their job to essentially train you up and get you ready so that you can pass the review board to get an invitation. So when I was living in Tennessee, I was doing a lot of training with him, preparing for this.
In Tennessee at the time, was there a board that also was tasked with reviewing applications for OCS?
Yes, there was.
And the cycle where you participated or your application was evaluated, do you know how many applicants the board authorized to go forward with OCS during that cycle?
One.
Was that your application?
Yes, it was.
Let's talk about OCS. At the time you began your journey in the Marine Corps, did Marine Corps personnel try to push you to a different area than you wanted to go to?
Yes, they did.
Describe to this jury what they asked you to do or what they wanted you to do.
As a recruiter, there are different boxes that I think you get bonuses in a certain sense if you can check, and one of those is the Marine Corps Band. So when they found out I had a background as a pianist, they really tried to get me to join the Marine Corps Band.
And when they asked you to join the Marine Corps Band, what did you say?
I declined. That wasn't the reason I wanted to join. I wanted to experience a different side of life, and I was interested in infantry.
Let's talk about OCS. During officer candidate school and your time there, were there metrics that were used by OCS personnel to evaluate physical fitness?
Yes.
Describe to the jury what those metrics were.
There's something called the PFT, the physical fitness test. And it consists of 3 areas. It's pull-ups to failure, maximum crunches under 2 minutes, and a 3-mile timed run.
What's a perfect score on that?
You can get a maximum of 100 in each of the 3 areas, so a perfect score would be 300.
What was your score?
294.
Ultimately, were you able to complete officer candidate school?
No, I was not.
Why were you not able to complete officer candidate school?
I was dropped after the 3rd week of officer candidate school due to level 3 stress fractures in both of my tibias.
So you had broken legs.
More or less.
At the time you were forced to leave officer candidate school, what percentage of the class were you in?
I was in the top 3%.
Do you remember how many members were in your OCS class at this time?
It was more than 400.
When you left OCS, how did you leave it with the Marine Corps?
The CO of Quantico, which is where Marine Corps OCS is at, asked me to return. He essentially told me to go home, heal, retrain, and come back.
And we'll talk about this more, but ultimately, did you return?
No, I did not.
At this time, do you consider yourself a United States Marine?
No, I do not.
Why?
That's a title you have to earn, and since I haven't completed my training, I did not earn it.
After you suffered the fractures in your legs, where did you go to rehabilitate and to heal?
I went back to Traveler's Rest, where my family is, and I stayed with them while I was healing.
And just to put a time on this, is this approximately 2019? Is that right?
This is late January of 2019.
So now you're living with your family in Traveler's Rest here in Greenville County. While you were living with your family and rehabilitating your legs, were you presented with an opportunity to play music?
Yes, I was.
Describe to the jury what that opportunity was.
Through a series of mutual acquaintances, a woman by the name of Jeanette Wynn sent me an email and asked me if I would be willing to play an inaugural concert for their church. They had just received a gift of a very fine piano, and they wanted to have this concert sort of as a thank you to the donor and to show the congregation what it sounded like.
And so you were asked to perform using the gift of the piano that the church had received, is that right?
Yes.
What was your response to that invitation?
At first, I was inclined to say no because I was about 6 months out of practice. But the more I thought about it, it seemed like it would be a good thing to do while my legs were healing, so I accepted.
Describe to the jury, when did you play the inaugural concert on the piano on that particular year?
I believe it was in June of 2019.
Were you to be paid for the performance?
Yes, I was.
Describe to the jury what the arrangement for the payment would be.
It was a flat fee honorarium for this one concert.
And was the concert well received?
Yes, it was.
I want to talk about, just briefly, you mentioned Jeanette Wynn in your introduction to the Wynn family. You first met Jeanette Wynn and other members of the Wynn family in what year? Was it 2019?
In 2019, yes.
And over time, did you develop a friendship with the Wynn family?
Yes, I did.
While you developed this friendship, did you share with the Wynn family a long aspiration you had held in the music context.
Yes, I did.
Tell this jury what that aspiration was.
Growing up, Beethoven had always been my favorite composer and something of a personal hero. And in 2020, that was going to be the 250th birthday for him. So I had this dream that I really kind of put on the back burner when I was intending to go through OCS. Well, this dream of playing all 32 of his piano sonatas in a series of concerts. And in passing, I shared this with the Winds.
And when you shared that aspiration you had with the Winds, what was the reaction of the Winds and their church members?
They were very enthusiastic about the idea.
And so their support of your dream, what effect did that have on your decision to go back to the United States Marine Corps?
Playing all of these sonatas is not something you can really just decide to do. You need a venue to present them at, so you need external support. And when I realized how enthusiastic the Winds and their church congregation were about this, I realized that there was actually a real way to do this. So it presented me with a very difficult decision, whether to go back to OCS or whether to do this passion project of mine that I didn't think I was going to ever be able to do. And I eventually chose to do the Beethoven sonatas.
Let's talk about this project. You said 32 Beethoven sonatas.
Yes.
How many pages of music comprises the 32 sonatas?
It's over 600 pages.
If you played those from beginning to end, how long would it take to get through all 32 sonatas?
It depends how fast you go, but roughly 11 to 12 hours.
To your knowledge, how many people have been able to accomplish this endeavor?
I don't know the exact number. It's not many. It's something, probably only a dozen or two pianists have ever recorded. As to how many pianists have actually done it, I don't know if there's a record of that.
So let's talk about what you did to prepare. We're in 2019. When was the first concert on this project? When was that? When were you to perform that concert? When was that scheduled?
In January of 2020.
Where was that going to be? Where was that performance going to take place?
At the Winds Church.
To prepare for this inaugural concert, where were you living?
At first, I was living with my family, and at a certain point, the Winds extended an invitation to me to live with them because they had a piano that I could practice on, and I think they wanted to hear me practice.
So let's talk about January of 2020. Did you have your inaugural concert for this project in January 2020?
Yes.
And where did you perform this concert?
At the Winds Church.
Were you to be compensated for this concert series?
The concerts were donation-based, and the church and I had agreed to split the proceeds 50-50.
Did you perform that concert in January of 2020?
Yes, I did.
How was it received?
Very well.
What percentage of the project, meaning how many sonatas, did you perform in the first concert?
I played 3 sonatas in the first concert.
When was the next concert?
In February of 2020.
How many sonatas did you perform in the second concert?
I think 2
When was the third concert?
in March of 2020.
And how many sonatas did you perform in the March concert?
I believe 3.
Was there were you able to perform a fourth concert in April of 2020?
No, I wasn't.
Why not?
COVID had happened, which was making public gatherings impossible at the time.
So up until April of 2020, if you had to guess, what percentage of the project were you able to complete in those 3 performances?
Maybe a fifth to a quarter.
All right. During this time, were you working anywhere else to make a little extra money?
Yes, prior I had been working at Gianna downtown serving, and at some point I started working there again after COVID had happened. And I also took on some work with my dad, painting houses and laying brick.
So when the pandemic hit, did that put a complete end to your music performances?
For the time being, yes.
At some point, did you decide to perform outside during the pandemic?
Yes, I did.
What instrument did you use to conduct performances outside?
I saved up some money and bought what was the best electronic keyboard on the market at the time, and I needed something portable, and I also wanted something that would do justice to the pieces I was trying to play, so it was a Roland V piano.
Where did you, or how did you get the money to pay for the piano?
Through working with my dad.
So after you got the piano, did you begin to play music on the streets of downtown Greenville?
Yes, I applied for a performer's permit for public spaces, and then I started on several times a week taking my keyboard downtown and playing these sonatas at various spots in downtown Greenville.
When did you start performing in downtown Greenville?
It would have been sometime in the summer of 2020.
Where were some of your most frequent locations where you perform music in downtown Greenville?
Probably the most frequent was right in front of Spill the Beans at the entrance to Falls Park, where the fountain is.
And I want to talk about an evening in August of 2020 while you were performing outside Spill the Beans. While you were performing, did anyone make contact with you and introduce himself to you?
Yes,
Who was that?
that was John Mello.
Was John Mello by himself, or was anyone with him?
He was with his daughter, Aida Mello.
How old, best you can recall, how old was Aida at the time?
She was 8.
Tell this jury about the interaction you had with John Mello when he first introduced himself when you were Principal Beans.
I didn't know who he was, but he came up and said he was a musician and asked if I'd be willing to take a request. He said his daughter's favorite piece was Claire de Lune, and I know that piece really well. It's a favorite piece of mine, so I played it for her.
What, if anything, did you observe about Aida while you were playing Claire de Lune?
Like I said, she was 8, so she was pretty young. I had taught a lot of kids before, so I had experience with kids that age and their attention spans, which tend to be very short. So I was really impressed. I could see her out of the corner of my eye, and she was just enraptured from start to finish. She wasn't running around, she wasn't on a device, she was just completely caught up in the music, and that made a big impression on me.
After you played John Mello's request, before he left, what, if anything, did he give you?
He gave me a business card.
Did you use it to make contact with him after that first meeting?
Yes, I sent him an email.
Why did you follow up and begin to communicate with John Mello after that first meeting?
I got the impression from a few things he said and from the card that he was in the rock and roll world, which that's something I had never had much contact with as a classical musician. And he seemed like a great conversationalist. He was charismatic and outgoing, and I thought it'd be interesting to get coffee with him at some point.
And did you meet with John again after that night in August of 2020?
Yes, I did.
I want to talk about the period between the time you met John and Aida Mello in August of 2020 until the beginning of October of 2020. During that period of time, how many times did you physically meet with John Mello?
Maybe 6 or 7 times.
When you met with him, was he by himself or was with Aida with him?
With one exception, Aida was always with him.
Tell the jury what the activities you and John and Aida would do together in that period.
We'd get coffee a few times. I saw them and Aida spontaneously because I was performing and they walked up like the first time. We got pizza once. We went to an art gallery, things like that.
Tell the jury what your impressions were of Aida as you got to know her in the late summer, early fall of 2020.
They were extremely positive. She's a really special kid. She was definitely mature beyond her years, like I talked about. She could hold a conversation with adults. She looked you in the eye. She seemed really cultured, like she'd had a lot of exposure to different places. She'd traveled like almost as much as I had. She was always telling me about trips she and her dad had taken, and it was just very evident to me that she was a very healthy, loved child. She clearly loved her dad, and it was obvious that he had done a great job raising her. And I was convinced that she was a happy, healthy kid, and he was a great father.
Let's fast forward to the beginning of October of 2020. When is your birthday?
October 2nd.
On your birthday, October the 2nd, 2020, how did you celebrate your birthday?
At this point, Aida had visitation with her mother, Christina Parcell. So this was the one time I saw John where she wasn't with him. And John wanted to show me some of his favorite taco stands out on White Horse Road. So we celebrated my birthday together and went to a couple bars, had dinner, ended up getting tacos at the end of the night.
At the beginning of the night, what was John's mood?
Very festive.
By the end of the night, had his mood changed?
Yes, it had.
Describe what his mood was at the end of the night.
Towards the end, at one of these taco stands, he became very pensive and even distraught. And he started to tell me about really grave concerns he had about his daughter, specifically when his daughter was with her mother, Christina Parcell. And he essentially said that whenever Aida's mother had visitation, he just never could rest easy until he got Aida back. And that he just didn't trust her, and he thought that she wasn't responsible and that she might even hurt her at some point. And I mean, frankly, the mood of the evening took a big dip because of this. It was clear that he just was terrified about the danger his daughter was in, and this made a big impression on me.
So, when you were with John on your birthday of October 2nd, 2020, where were Aida and Christina Parcell?
I believe they were on a road trip to see family, maybe in Alabama or somewhere farther down south.
When was she due back to Greenville?
I believe the next day, or in the next couple of days.
When she returned, where were Aida and John going to go?
They were going to go to Italy.
Did John tell you that?
Yes.
When John told you that he and Aida were going to go to Italy, what did you think about that? What was your reaction to that?
I thought it was great. I knew at this point that John's parents were Italian, and Aida, I thought, stood to gain a great cultural experience from it. And I just thought if I had had the opportunity to travel and live in Italy when I was 8, I would have jumped at that. So I was really excited for both of them.
Did they go to Italy?
Yes.
So in October, John and Aida Mello go to Italy. Tell this jury what you're doing in October, November of 2020, musically and otherwise.
At this point, musically, I was still performing on the streets of Greenville, and I was also talking with someone who curated a museum of historic instruments downtown, the Sigel Music Museum. This man was Tom Strange, and we were discussing the possibility of revamping the Beethoven project I had been planning to do that got cut short by COVID by essentially doing the concert series again throughout 2021, but this time recording them so that we wouldn't have to deal with the issue of gatherings with COVID going on.
And did you and Tom Strange solidify a plan for resurrecting the Beethoven project?
Yes, we did.
Just generally speaking, describe for the jury sort of the intensity of the schedule, the intensity of the lead up to that project.
Yeah, so as a classical musician, at least, just because you've played a piece doesn't mean that like you know it forever and you're never going to forget it and it's never going to cost you any more work. It would be like you may have run a marathon once before in your life, but if you haven't trained for a year, it's not going to be easy for you if you go and try to do it again. So I was going to have to relearn all of this repertoire because I had only been playing certain of the sonatas downtown. And with the recording schedule, I was going to be meeting with him. There was going to be other people and other equipment involved. So essentially, I was going to have to commit to a schedule where we'd meet more or less once a week to record one sonata a week throughout 2021 and stick to that schedule. So it was going to be strenuous and a lot of work, and I knew this going into it.
And when was the first recording set to occur on the project with Tom Strange?
I think around January 2021.
And beginning in January, how many performances on the project? What was the time frame on the remaining performances on the project?
Again, it was roughly one a week. These sonatas are not all the same length. Some are short as like 12 minutes. Others, one lasts about 45 minutes. So depending on the piece, we were allocating enough time for me to get ready.
All right, so let's talk about from, again, October to April of 2020. John and Aida leave in October. Between October and April, describe to the jury what the communications were you were having with John Mello, the frequency of the communications. Just tell them about it.
Like I said, I was excited for them. I was excited for Aida to be able to have this experience. Based on what John had told me about Aida's mother, I thought it was good that there was distance in between them. And our communications had died off a bit after they left. John is interesting. He's also a lot. He's a very dramatic person, and it was a bit of a relief to just not be running into him downtown all the time, because I had a lot of practice I was doing, and sometimes I didn't have time to hang out as much as he might have wanted to. So our communications petered out.
Were you relieved in some ways that your communications with him had slowed down or stopped?
To a degree, yeah.
All right. In April of 2021, did your communications with John and the frequency of them increased dramatically.
Yes.
Why did your communications with John increase dramatically in April of 2021?
Like I said, our communications had petered out, but they hadn't completely ceased. So he had let me know that Christina Parcell, Aida's mother, had been filing, I think, some stuff with the family court in Greenville in order to try to get her daughter back. He was very worried that she might succeed in doing this for reasons I've already spoken about. And in April, he sent me a message, and it was clear from the text that he was very upset, just saying that, Zach, they took Aida. What am I going to do? Something about along those lines.
After he told you in April of 2021 that they had taken Aida, did he begin to tell you in greater detail what his concerns were and more information about his concerns?
Yes.
What happened next?
At this point, I found myself in kind of a conundrum because, like I said, I had appreciated having some distance from John. But by the same token, I was becoming increasingly more concerned about his daughter, Aida. So while I might have wanted to not continue communicating with John for the sake of his daughter, I felt that I had a certain sense of responsibility to help him with what he was dealing with this custody battle for his daughter's sake. We began communicating probably every day, at least by text, often by phone calls. I was giving a lot of time towards hearing what he had to say, towards trying to help him in any way I could. Some of the things I did to help him were, first, he needed counsel. He needed a lawyer in family court. So I was calling a bunch of lawyers in Greenville, trying to find someone who could help him, and by helping him, help Aida. I ended up cleaning his house in Greenville. He had left it with a tenant who absolutely trashed it. It was like nothing I'd ever seen. Like the air was hardly breathable. So I was buying a dehumidifier, getting cleaning supplies, hiring Mikey Manigo, who testified last week, to help me clean out his house so that he would have a place to show family court, and that he had a home that would be a safe place for a little girl and him to be living in. I told him when he came back, I'd pick him up from the airport. But notably, while we were having these conversations, he began to tell me in much more detail what his concerns were about Christina Parcell. And, well, in order for you to understand what my reaction was to what he was telling me, you need to know what my experience was with my oldest adopted sibling, Grace. So when we adopted these kids, we really didn't know much about them.
Objection, Your Honor, may we approach?
Sure. please take the jury back to their wonderful room.
Oldest sister. Please, court. Zach, where we left off, you were telling this jury about your oldest sister, Grace.
Yes. Thank you. I don't say this lightly, but my oldest sister, Grace, was the most evil human being I've ever met in my life. She was 10 when she came into our family. The Russian government didn't tell us much about the kids, so we weren't aware of any, if any, behavioral issues. There may have been, and there were many, but specifically with her. I would describe her without reservation as an affectionless psychopath. It wasn't that she was immoral, it was more that she was amoral. She didn't have a sense of right and wrong. Her emotional compass was seemingly non-existent. She was just dead inside. She was a masterful manipulator and deceiver. She could lie at the drop of the hat for reasons that might involve her personal gain or just for the heck of it. She would invent the most absurd, crazy, gruesome stories just to get a reaction out of people. And she could talk about this stuff with the same tone that you might talk about making a sandwich. And this from a girl that I knew between the ages of 10 to 14. It was incredibly disturbing, and the things I learned about that type of personality have stayed with me my entire life because I've never met someone like this since. And with one exception, I had never even heard someone describe another human being like this. And one of the things that is so dangerous about someone like this is she was literally like a vampire who would just suck the goodness out of other people around her. She could be very emotional, and she would fake these emotions in order to elicit a response in you, a sympathetic response. And if, for instance, you were accusing her of doing something like stealing or hurting one of her siblings, she would weep and just beg you to believe her and say, no, I didn't do it. And then if you would present her with irrefutable proof that we knew you had indeed done this, it was like a mask would just fall off her face. And I mean, she'd just look at you with shark eyes. And no matter how many times we would go through this cycle with her, where she would deceive us and betray our trust and hurt people in our family, she would always reel us back in, because there's something in normal, good people that wants to believe that someone like this can change. You want to believe that, there's redemption for someone like this and that they might change their ways and become a better person. And she knew that. And she would use that in order to ingratiate herself again and regain our trust, only to betray that trust again harder than she had the first time. And this happened dozens of times, and it created an incredible amount of strife in our home. She could manipulate my parents and drive a wedge between them. She was just an incredibly intelligent person and incredibly evil. And having met someone like that, it made me able to understand, and even though I didn't want to, accept the fact that people like this exist, whether you want to believe it or not. And if you trust them, you are only ever going to get hurt by them again. You have to forgive them at some point. And that was a very difficult thing for me to do. It took me years, but eventually I had to accept an apology from this girl that I never got and was never going to get. And I had to do it for myself. But I would never trust her again. That would be insane, for my own safety or for the safety of others. So this is an experience which I think is somewhat unique. I think most people have not met someone like this. And I mean, we might watch true crime documentaries or things like this, and we know that technically these people are real, but they exist on Netflix or in someone else's lives, and we never once believe that it could be someone we know, or that it could be someone living next door, or that it could be someone that our children play with, or someone we might allow to look after our kids. So knowing this is essential to understanding my reaction to what John began to tell me about Christina Parcell in April and May of 2021, after Aida had been taken back to Greenville. He started describing Christina Parcell's character and her personality. And as he was going through various points, he kept saying, Zach, I know you're not going to believe me. Like, I know this sounds overblown and dramatic, and you probably think I'm exaggerating. And under other circumstances, I would have, because John he's a big storyteller. And, when people are talking about their exes, like, everyone thinks their ex is the Antichrist. So, of course, I was sort of predisposed to be biased against what he was telling me, except for the fact that point by point, everything he described about Christina Parcell was exactly the same as my sister Grace. He told me that Christina Parcell was a master manipulator. He said she can lie at the drop of the hat and you'll never know it. He said she was incredibly charming. He said she was incredibly intelligent and talented. He used to say she was smarter than he was, but that her biggest fault was that she was lazy. And she had this arrogance combined with her laziness that was essentially born out of the fact that she knew she never really had to work too hard at anything in life. And she could even sacrifice trust with people and tell them lies that could easily be found out, because ultimately she was completely confident in her ability to reel someone back in, no matter how bad she had burned them before. And he could have been describing Grace to me because I knew this behavior. I had lived through this behavior. So at this point,
I'm sorry. When he was describing these features to you of Christina, had you ever told him about Grace? Did he know anything about Grace?
no, I don't make a habit of talking about Grace to people. One, it's incredibly difficult to speak about, and two, most people, having not met someone like that, it just doesn't really land most of the time. They don't understand what you're talking about. So no, John had no idea that I'd had this experience with Grace, which made me realize that there was no way he could have possibly invented this, because no one would get it right point by point by point unless they had met one of these people. And that was the first thing that really raised a huge red flag with me and made me think that despite the fact that he can exaggerate and overblow the truth, and he's often not very believable when you listen to him, I was convinced at that point that he must be describing something true, because no one would know how to describe it so specifically and accurately if they were just making it up. And I was right to believe him. So, in addition to this description of her character, and one last thing about Grace and Christina by correlation, one thing Grace was she had an addiction to doing was not merely stealing from you or sucker punching one of her siblings just to assert dominance or doing other terrible things to her siblings. She would recruit her other younger siblings to do these things for her. She would get off on making little duplicates of herself and training and enlisting her siblings to act as proxies for her, so that she wouldn't actually get in trouble, because she knew that we all had our eyes on her because of her behavior, and we knew we couldn't trust her. So if she even had 2 minutes with one of her younger siblings where no one was within earshot, she would tell them, "Hey, Mom's gonna go check the mail. I just saw the mail truck go. When she's doing that, I want you to go run into her bedroom and go into her jewelry, or go and get this for me and we'll split it. Go and get that food that Mom said we can't have till the weekend," or something. So she was an incredibly corrupting influence on anyone around her that she could exert her influence on. Again, I called her a vampire who sucks the goodness out of others. This is an incredibly appropriate metaphor, because that's what vampires do. They're intelligent, they're dead inside, and they eventually kill the people around them unless they find someone who might be useful to them, and then they create a duplicate of themselves that they can control. And this is exactly what Grace would do. So when John was telling me all this, I realized that there was an incredible danger that what Christina Parcell was a future preview of what John Mello could potentially become if she was left in this woman's custody and was raised by her. And the facts have borne out that I was right. But
Sustained. We'll instruct the jury to disregard the last comment.
Zach, at some point, was Grace actually removed from your family?
yes.
Describe for this jury why, or the circumstance or the event that prompted her removal from your family.
It had been 4 years of what I've been describing. She had been sent to different girls' homes around the country, many of which had records of never expelling a single student, and she was the first for many of them that they expelled and sent back to us. And it finally just got so bad that we realized she was going to be a physical danger to our family. I discovered a diary that she had made where she described in detail my parents having their eyes gouged out and dying, and how once my parents were out of the way and dead, she would be able to assume her role as rightful queen of the country. So she just had these psychotic, psychopathic delusions of violence and grandeur. And we called the SS and asked them to remove her from the home.
We're going to come back to that in a second, or in a little while. You testified about things that John told you about Christina. Did he also provide you with other information about Christina that informed your opinion of her or what you came to know about her?
Yes.
What were some of the documents or other pieces of information that John provided you?
No objection, hearsay.
No, we're not offering it for its truth. We're offering it to show what he knew. It's in State versus Vic, I've cited, Your Honor, we are not offering it for its truth. Go ahead.
He offered me, among other things, three very pertinent collections of information. One was the photographs that have been discussed that I sent in mailings to various people, along with advertisements from an escort website, which were connected with these photographs. These photographs were of Christina Parcell in various stages of undress. And John told me that they were prostitution advertisements from her previous career as a prostitute. And looking at these photographs, there was no doubt in my mind that that's what these were. And I don't say this in any way to try to shame. It's simply that, I mean, who said it? Like pornography, you know it when you see it. Well, I think the same can be said in terms of these photographs. They were not cute, sexy, intimate photographs that someone might send to someone they're dating or something. They were lewd and tasteless, and there was a very clear element of advertising, a commercial element. So when I looked at these, there was a vacant, arrogant, almost derisive look in her eyes that reminded me so much of my sister. It was a look that said, I can get you to do whatever I want because you want what I have to offer you. And coupled with this was a deposition from 2016 that Christina Parcell had given.
In 1 second, Zach. Let me show you, Zach, what's been marked as Defense Exhibit 46. Take a look at this.
Yes, this is the deposition.
All right. This time, the defense removed Defense Exhibit 46 into evidence.
State objects.
Not hearsay.
Not here.
I did as far as that.
Yes, sir. After, Zach, after you read the deposition you referenced of Christina Parcell, what did you come to conclude or believe?
I believed that based on various things she freely admitted to in her deposition, that she had a history of using and manipulating men in order to get money and in offering sexual services in return. She admitted to being a pornographic actress and producing a film in South Carolina where she rubbed her feet on a man's penis. She admitted to using sugardaddyforme.com, where she sought out romantic relationships with older men with a clear emphasis on it being a trade, essentially a reciprocal thing, where she was seeking out to be taken care of financially. She said that she had a general disinterest in having children at the time, which is why that she gave up custody of her daughter to John Mello when her daughter was very young. Her lawyer took it.
Objection, Your Honor. I'm going to sustain the objection.
Okay.
You can ask him, like he said, as far as just the effect it had on him,
Understand.
not the specific details.
Understand.
Move on.
Zach, a little while ago I asked you about documents that John gave you in addition to details he provided you, information. We talked about the deposition. Let me show you Defense Exhibit 56. Let me show you Defense Exhibit 56. Is that also a document that John Mello gave you?
Yes,
Did you read it?
I did.
At this time, the defense removed Defense Exhibit 56 into evidence.
State objects based on the same objection we had in the prior, the prior issue. I think Your Honor's ruling was that he can talk about how it had an effect on him, but not to go into the details.
Your Honor, this is a separate exhibit. It's different than the deposition. It's just a few pages. I'd be happy to argue on to Your Honor on this.
I'm going to allow this to come in.
Okay.
Thank you very much, Your Honor. This is, so again, I will renew my motion to enter Defense Exhibit 56 into evidence. And it's admitted. Is that correct, Your Honor?
That's perfect.
Zach, take a look at Defense Exhibit 56. Would you, for the jury, let me look at it. Let's do this. Let's see. Here. Zach, this is an affidavit of a man named Alex Fields, is that correct?
Yes.
And I just want to go over this affidavit for you, or with you. Based on your understanding of this affidavit and your communication with John Mello, how did John become aware of this information that led to this affidavit?
John posted an ad on Craigslist asking for information about a woman named Christina Parcell, aka Caroline Warren, and he provided photographs to identify her by.
Is page 2 of the affidavit this advertisement on Craigslist?
Yes.
Okay, let's go to page 1 of the affidavit. Would you please read the second paragraph of this affidavit?
I was at Hall's Chop House in downtown Greenville, South Carolina, when a woman approached me. She said hello and proceeded to ask if I was looking for a date. She said something to the effect of inviting me to bed for an amount of money and that we would not be rushed at all. When I refused her proposition, she proceeded to offer me narcotics. I refused and ended the encounter at that point.
Would you please read just the first sentence of the third paragraph?
There is absolutely no doubt in my mind that this woman is the woman that I saw on Craigslist.
And Zach, again, the woman in this advertisement on Craigslist, who's that woman?
Christina Parcell.
Zach, I want to talk about other information John Mello had provided you. You heard testimony from investigator Dan Bell. Do you remember that testimony?
I do.
And do you recall in the state's case in chief, Dan Bevel, both in direct examination and cross-examination, testifying that he had met Christina Parcell in his official capacity before he began his investigation of the letters that were sent?
I remember.
And isn't it true that John Mello shared information with you about interactions he had had with Dan Bell?
Objection.
Objection.
Your Honor, I need a curative instruction on that.
You know, I totally disagree, and I'm happy to argue.
Thank you for your patience. I just had to take up some legal issues with the attorneys. Y'all are gonna get your steps in today. Please proceed.
Yes. So, Zach, you testified about information that John has provided you related to concerns he had about Christina Parcell, especially in conjunction with Aida Mello. We talked about the time period April. I want to move to May. In May of 2021, were you and John Mello continuing to communicate about the situation?
Yes.
In May of 2021, what, if anything, did John ask you to do for him?
Given the extremely grave nature of John's concerns for his daughter, especially while she was in the custody of her mother, Christina Parcell, and potentially being exposed to her mother's boyfriend, Brad Post, who John believed was a pedophile and is a pedophile.
Objection.
Sustained. I instruct you to totally disregard the last comments made by this defendant.
And Zach, could you just tell this jury what John asked you to do?
Yes. Given his concerns, John asked me that if I believed his daughter was in grave danger, would I be willing to kill Christina Parcell for $5,000?
What did you say when he asked you that?
I was shocked and insulted by the request, and I gave him an immediate and unequivocal no.
So he offered you $5,000 if you would kill Christina Parcell, and you said no.
That's correct.
At some point, did he revisit that subject?
Yes.
Did he make you another offer?
Yes, he did.
How long after the first offer did he make the second offer?
I'm not certain, but I would say maybe 2 or 3 weeks later.
Tell this jury about that.
He was becoming increasingly more worried and distressed about the safety of his daughter. I was as well. The more I learned about this situation and everything, and a lot more than what I've told you, I was also.
Sustained.
What was the second offer?
The second offer, he asked me again, if I became convinced that his daughter was in danger, would I be willing to kill Christina Parcell for $10,000?
What did you, or how did you respond to that offer?
I told him, John, there's no amount of money that would ever tempt me to do something like this. And I told him I was insulted that he even thought that would be something I would consider. So I told him I would never do something like this for money. I told him the only way I would ever consider taking action like this is if I was absolutely convinced that his daughter was not only in danger, but that the only way to rescue her from that danger would be to take Christina Parcell's life.
Let's talk about what else is going on in your life in May of 2021. Tell this jury what you're doing with the music project with Tom Strange, how that's going.
We've been at the project recording the sonatas in the museum, like I talked about, for about 5 months. This, of course, I was doing in conjunction with all the help I was trying to provide John and Aida. So the music project on its own would have been incredibly stressful. And with everything else, I was just approaching burnout. Honestly, I was having a really hard time meeting my deadlines. And I was worried that the quality of the work I was doing was going to be going down. And I was just at the point where I needed a vacation, honestly.
And we're going to get to that in just a second. Tell the jury about your compensation as it relates to the music project with Tom Strange.
It was just an arrangement of a flat fee for all 32 sonatas. I was going to receive $5,000.
And if you broke that down on an hourly basis, how much were you getting paid per hour for that project?
Probably less than $1, but it was a labor of love.
During this time, were you also doing other things to try to make money to support yourself, or was it?
Yes, I was giving some outdoor concerts on the Wynn's lawn, and these were donation-based, so people were supporting me financially in that regard.
You talked about needing a vacation at the end of May. Describe a little bit more to the jury the fatigue and why you believed at the end of May that a break would do you some good.
Well, I needed a break. My nature is usually to just try to push through stuff like that. I can push myself too far. So I was not necessarily seeking out a break or a vacation, but I was definitely at the point where I needed one for the sake of my work, for the sake of my health.
Did you get that break?
Yes, I did.
Describe for the jury how that came about.
Like I said, John and I were communicating pretty much every day at this point. Much of it, if not most of it, about Aida. But I was also mentioning to him what I was doing. Certainly times when he needed me to do something and I would have to say, I can't, I'm practicing, I'm recording something like this. So he told me, I think he said, like in the rock and roll business, we say you have a monkey on your back. Like the project is starting to own you and you just need to step away from it. You're too close to it and you've been in it for too long. So he suggested that I come and visit him in Italy.
Did you take him up on that suggestion?
Yes, I did.
Initially, what was your reaction to that offer?
Initially, I didn't want to. Like I said, it's my nature to just kind of push through things, but with some more time, I realized that some time off from the piano would probably do me good.
So when did you go to Italy to visit John?
I think in either the very last days of May or first days of June, 2021.
Who paid for your travel?
I did.
When you arrived in Italy, where did you stay?
I stayed at John Mello's apartment.
How long were you there?
Between 3 and 4 weeks.
Do you remember where in Italy you were?
Yes, it was a town called Rovigo. It's not too far from Venice.
When you were visiting in Italy, where was Aida Mello?
She was in Greenville with her mother.
Even though Aida was not in Italy, while you were in Italy, did you have an opportunity to see Aida?
Yes, I did.
Describe for the jury what that opportunity was.
John had video visits ordered by the guardian ad litem, who you've seen before, Vanessa Cornlow, to have video visits twice a week with Aida. So he, even with the time difference, was always setting timers and alarms and making me set timers and alarms to make sure he wouldn't be late for these visits. Like, he lived for these visits every week. So often it might be 11 p.m. or midnight in Italy, but that was when Aida was free, so that's when they'd have their visit. And I would often be within earshot to where I could hear their conversation. Often I would be able to observe the screen of his phone or computer, so I could see Aida's face, her disposition. And on one occasion, I said hi to her.
What did you notice about her, or what did you conclude about her while you were watching Aida during these visitations?
So John had been telling me for weeks, Zach, Christina's killing my little girl. Like, I can see the spark dying in her eyes. And again, when I first heard that, I thought, aren't you being a little dramatic? Like, I hadn't seen her, but it just seemed a bit much. When I saw her in these visits, I didn't feel that way anymore. She was not the same little girl that I had known in Greenville when I first met them. She had put on a great deal of weight, probably about 20 pounds, which is roughly a quarter of her body weight. For an 8-year-old girl, that's a lot in a short period of time, but it was much more than that. It was her demeanor. Her spirit was just, she was morose, she was depressed. Like that spunky, precocious, lively little girl that I had met was just not present there. It was a complete change in character. And I mean, John would ask her how she was doing, and she would always try to give a good response. Like, she would try to smile and say, "Oh, I'm fine, Daddy," and try to put on a good face. But it was clear that she was doing that because she didn't want to worry her dad. She didn't want him to realize how poorly she was doing, and it just reminded me so much of myself when I was a little older than she was, with what I've previously described with Grace. It's this, you internalize things. Like, she's a strong person, and she was trying to be stronger than she was probably ready to be at that age. And despite the stoic, strong exterior she was trying to put on, I could just see that she was being tortured. Like, she was drowning, and him saying that the spark was dying in her eyes was absolutely accurate. I could see it, I could hear it in her voice, I could tell it in her demeanor.
So, when you came, let me back up. When did you leave Italy to return to Greenville County?
At the end of June 2021.
When you returned to Greenville in June of 2021, based on everything that you knew and had been made aware of, and I want to start in June, what, if anything, in June of 2021 did you do to act on what you knew?
I had described the mailers that I had put together before, and the state has talked about them a lot. All of these mailers contained information that I believe had been put out publicly and by Christina Parcell's free will. So this was all information that had been available publicly, and that, to the best of my knowledge, was true. And I began to send these mailers to Christina Parcell and her boyfriend and people in the neighborhood for a threefold purpose. I wanted parents around that neighborhood to know that their children were not safe around her or around Brad Post. I wanted different people associated with this, such as the guardian ad litem, the police, to have access to this information, so that they would have all the evidence that I was looking at that clearly demonstrated that Christina Parcell was a danger to children and her own daughter. And I also wanted there to be social pressure on Christina Parcell, because something, again, about people like Grace and Christina Parcell is the facade that they erect around themselves and the image that they put forward to the world is so important to them. They're narcissists. And it is a facade. It's completely untrue. But I was hoping that it wouldn't be worth it to her for other people to see her for what she was, in exchange for her trying to fight to have her daughter.
You sent multiple mailers beginning in June and going into July of 2021, is that correct?
Yes, I did.
Did those mailers and the effect those mailers had do anything to alleviate your concerns?
No, they didn't. If anything, Christina Parcell and Brad Post just dug their heels in deeper.
After the mailers were sent, do you know whether or not they had any effect on, let me back up. I want to talk about, after the mailers were sent, did you learn of a video call or about a video call that John, who was in Italy, had with Aida, who was in Greenville?
Yes.
What did you learn about that video call?
Shortly after these mailers would have arrived, John described a call to me where he said Christina was, at the end of the call, she took the phone and turned it towards her face, which she usually did not do. And he said she was more angry than I've ever seen her. And he would often talk about how you would never see her angry, like she was very good at controlling her emotions and not showing if you had made her angry. And she took the phone and didn't say anything, but just slid her finger across her throat as if that she was threatening that she was going to have him killed for what she believed he was doing.
After the mailer, or the last mailer, did John share with you any information he had received via email?
Yes, he didn't describe it, he sent it to me. An email he had received from someone he knew in the biker community, motorcycles. And Brad Post was also involved in the biker community, or at least tried to be. And this email was from this acquaintance of John, telling John that Brad Post had been going around essentially asking for someone to, quote, put the hurt on John Mello, and that he was offering a lot of money to make this happen.
Don't come up here. I'm going to sustain the objection. That's to your side.
Zach, we talked about the fact that you testified that you sent the mailers, you've explained why. I want to talk about something else you did for the purpose of acting on a concern. Take a look at what's been marked as Defense Exhibit 47. Is that an affidavit that you completed for the purpose or in connection with the pending family court litigation between John Mello and Christina Parcell?
Yes, it is.
Your Honor, this is defense counsel version. This is already in evidence, and the state put that in. Zach, let's talk about this affidavit.
Is that the one from September?
Yes, Your Honor. Yes. Zach, why did you draft this affidavit?
I was extremely concerned about the danger that Aida was in, and I wanted to try to provide the family court with information about my opinion and my observations about her that would hopefully cause them to return Aida to John so that she would no longer be in danger.
Did this affidavit, well, let me back up. To whom did you send this affidavit?
I had it notarized, and then I think I scanned it and probably emailed it to John or left it with his family court attorney, Samantha Larkins, at the time.
One second. Let's move on. So that affidavit was, I believe, September the 21st of 2021, is that correct?
I don't remember the date other than it being in September.
I'll show it to you.
Yes, the 21st day of September, 2021.
And you testified that after you submitted that affidavit, that did not do anything to alleviate your concerns, is that correct?
That is correct.
Did you take another step to try to act on your concerns for Aida?
Yes.
And did you take that step at the end of September or beginning of October?
Yes, I made a phone call to Child Protective Services, and I told them that I was a neighbor. So I told them that I had seen Aida being verbally and physically abused by her mother. And again, I made that up. That's not true. But I said it because I wanted to give Aida an opportunity to have FaceTime in person with an agent from DSS away from her mother, where she could tell them that her mother was sexually abusing her.
Objection, Your Honor.
Sustained. You are to disregard the last comments from this witness.
Zach, let me ask this. You talked about Child Protective Services. Is that in South Carolina, is that called DSS?
I think they may be part of the same entity, I'm not sure.
And so did they do anything to alleviate your concerns?
No.
Did that surprise you at all?
No.
In fact, you testified earlier about Virginia and Grace. Did you and your family have interaction with the DSS in Virginia
Yes, we did.
over Grace?
Yes, when I discovered the journal, I had mentioned before about Grace's plans to murder my family. We called DSS and asked for her to be taken out of the home. And they did this. And after a few weeks of hearing Grace's stories and lies, they took her side. They failed to recognize what they were dealing with her. And they tried to have my parents put in jail and the rest of me and my siblings put in foster care. And we eventually had to sue them, and it was about a 2-year-long court battle. And that left an indelible impression on me, just as to how even experts can be wrong sometimes. And when they are wrong, it's so dangerous because everyone believes them because they're the experts. But sometimes you know what you know, and you know it's true, and even if an expert might think differently, it doesn't mean they're right. And DSS did a lot of damage to my family in those 2 years.
So ultimately, Grace was removed from your family, is that correct?
Yes.
Your other Russian siblings were not, were they?
No.
And in fact, Faith, one of your Russian siblings, has been in the courtroom all week, is that correct?
Yes.
So you testified to this jury about the information you received from John Mello about his concerns. You've testified to the jury about the documents you consulted about those concerns. You testified to the jury what you came to believe. You testified to the jury about the mailers you sent, about the affidavit you submitted, and now about the call to DSS. After you had done all these things to act on your concerns, and nothing had been done, tell this jury in early October of 2021, what's going on in your mind? What are you thinking?
I was still in the middle of this music project, so I had a lot on my plate there just professionally, and of course I was continuing and even increasing my support to help John save his daughter, Aida. And since June, when I had returned, I had been absolutely convinced that Christina Parcell was sexually abusing her daughter.
John, let's go. I mean,
Take the jury.
this case with you and sort of explain the state's perspective and how we have proven beyond a reasonable doubt
that Zach Hughes did in fact commit the crimes that he's alleged to have committed. And I'm going to go through those crimes a little bit, and we'll talk a little bit about that. And then I'm going to go briefly through the evidence and explain my perspective on those things. I will give you a bit of a caveat that this is a little bit of a unique case in that you rarely have the defendant testifying and admitting to the entire crime during the trial. So in that respect, my closing argument may be a little different or maybe a little abnormal than our normal way we do things, but I'm going to do my best. I first want to thank you for your service. It's been a long 2 weeks. Y'all have been extremely attentive. You've paid attention. You've listened to the judge. And to be frankly, I couldn't ask for a better jury, and I appreciate your service. On behalf of my co-counsel, Mr. Jake Hofreth, Investigator Jared Sparkman, and Master Deputy Blake Wolf, we thank you for your service. Now, I told you in my opening statements that once you see and hear all the testimony in this trial, and I did not know that the defendant was going to testify, you're going to find that Zach Hughes, I don't know if you remember what I said, is a cold-blooded killer. And I submit that the state, and along with the testimony of Zach Hughes, we did in fact prove all of that beyond a reasonable doubt. Zach Hughes is a cold-blooded killer. Zach Hughes is an admitted cold-blooded killer. And keep in mind, he solved John Mello's problems. So the judge is going to instruct you on the law, and just as we're going to abide by his rulings, you must abide by his instructions. Remember, I told you he's the referee, calls balls and strikes, and he also tells us what the rules are, what the law is. Y'all took an oath way long ago than you can probably remember, back in last week on Monday, a week ago, and you said you would take an oath, you would adhere to his instructions, you would do your duty as jurors, and I have no doubt in my mind that you will absolutely do that. Now, before Zach Hughes admitted to the murder of Christina Parcell, the state called approximately 32 witnesses. We submitted close to 200 exhibits. If you put all this on a hard drive, it's a little over 4 terabytes of information. And all of that taken together, it's a lot of evidence to digest. Now, with the admission of Zach Hughes to a lot of the state's case, the questions you were presented with at the beginning of the case really are answered. Regardless of what he may believed in his head, his actions are what matter in this courtroom. Actions speak louder than words. And boy, do we have a lot of cold, calculated, horrific actions in this case. Now, ladies and gentlemen, you must find the facts based on the evidence in this trial and solely based on the evidence presented at this trial inside this courtroom. And it is undisputed that Zach Hughes planned, he lay and waited, he broke into Christina Parcell's home with a .22 and a knife, some roses. She had just returned home from an interview, from her last interview with Vet Tech. Zach Hughes, a person she had never met, she had never met him, beat her with a gun, brutally stabbed her 35 times, severing her jugular vein and her carotid artery. Now, as we go through the evidence and we look at some of the different things, I'm going to ask you to keep in mind of the charges that you're actually looking at. So the first charge I'm going to explain is the harassment charge. And there's 2 harassment. There's harassment and there's conspiracy to commit harassment. The only difference is the conspiracy requires 2 or more people joining in to commit the harassment. So harassment is just a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that serves no legitimate purpose and causes that person and would cause a reasonable person in his position to suffer mental or emotional distress. That's related to all those photos and those documents that you saw mailed out. I think there's 7 envelopes full of photos and other documents. You heard testimony about what was in those. Some of them are in evidence, some were just described, because those were pictures of Christina Parcell without any clothes on. So we didn't introduce those so as not to embarrass her or her family. Burglary first. A person is guilty of burglary first if he enters a dwelling without consent and with the intent to commit a crime. And I remind you, the judge is going to tell you the law is, what it is. I'm just trying to give you an outline so you can keep that in mind as we're going through this evidence. And they enter without consent and they're armed with a deadly weapon or cause physical injury. Well, those things all already appeared in this case. Zach Hughes went in under a ruse of roses according to his own testimony, but he went in directly with the intent to commit harm and he had weapons on him. And then you've got murder. You also have possession of the weapon during the commission of a violent crime. That is, if you used a weapon and you murder somebody, that is the possession of the weapon during that commission of a violent crime. But you have murder, which is the killing of any person with malice aforethought. Malice aforethought. And you're going to hear those words a lot in the judge's instructions. But malice is ill will towards another person, the intentional doing of a wrong act with the intent to inflict injury. And I think I said early on, ladies and gentlemen, it was a depraved heart, an angry heart with the intent to harm somebody. And there's also express malice, meaning it's expressed, it's right there in front of you. And it's shown when there are words of hatred or when someone prepares to do the act. They prepare to go in there. It's called premeditation, is what you'll hear the judge charge you. Premeditation is preparing to go and harm somebody, like lying in wait, like buying weapons beforehand, by concealing your identity going in there. Those kinds of things are premeditation, things that you do in preparation of the violent act. And if you find those things, and you find the state proved those beyond a reasonable doubt, then you can find the defendant guilty. So before we get in, let's start with a little background now. You know the players, you know everybody involved in here, you know the victim. You've heard a lot about the victim, Christina Parcell. You've heard a lot about John Mello. You've heard a lot about Zach Hughes. And you've heard a lot about Christina Parcell and John Mello's daughter. So the background, and we're talking the time frame from 2020, October 2020-ish, to October 13th, 2021. So we're roughly a time span of 1 year. And what happens throughout that year that leads up to the murder of Christina Parcell? Zach Hughes never talked to Christina Parcell. He didn't know Christina Parcell. He never met Christina Parcell. And everything he knew about Christina Parcell, even according to his own testimony, was told to him by John Mello or shown to him in certain evidence. John Mello was in a nasty custody battle with Christina Parcell. We all know that. He was on his 4th round of custody disputes with Christina Parcell. Keep in mind, and according to the guardian ad litem, the prior 3 were just as nasty, but they had always been settled where John Mello would have significant custody of their daughter. But in April of 2021, that changed. The tide changed for John Mello because he took Aida out of the country in violation of that order, according to the Italian courts. And he took her to Italy. And Christina Parcell didn't even know about that until she saw a social media post where she realizes, my daughter's out of the country, I can't see or talk to her, and she's with her father. Thus, the continuation of this nasty child custody dispute. And then from October to April, Aida was living in Italy with little or no contact with Christina. So what did Christina do? She did what any mother would do, is she tried to get the return of her daughter. So she went through this process, and it was explained by Christina's sister, Tina Parcell, as well as the guardian ad litem, Vanessa Cormelo. She filed under what's called the Hague Convention, and she asked to have her daughter returned to her. She actually flew to Italy twice to have these hearings in Italy. And she was successful. She won that particular battle in this myriad of battles of child custody that had been going on between these two individuals. And so in April of 2021, that really set off John Mello. He was unhappy. And we know the things, and we're going to talk about the things that he did starting that day, through the WhatsApps, through the harassment letters, everything else, to solve that custody dispute problem. And that's where this case really, really began. That is when things turned not in favor of Christina Parcell. She lost her life as a result. So what is the relationship between Zach Hughes and John Mello? All right, so where did they all come into this mass of characters? Well, according to Zach, he met John on the streets of Greenville about August of 2020, and he was with Aida, and Zach played a very likable classical music piece that John Mello and Aida liked. And that's how they met. So they met that one time. And that was one of the few times that Zach Hughes actually met Aida Mello. She's a 9-year-old little girl who heard him play a piano piece, who's a friend of her dad's, and that's all the time they ever spent together. That's it. In August until October, John Mello left for Italy, and with him went Aida. So Zach Hughes never spent any more time with Aida, what little time he did during that small time, ever, never again. Now, he may have seen her on a FaceTime while he's talking to her dad. He may have seen her or seen videos of that, which he testified to. But Zach acted on this stand as if he could see into her soul. He could see into her eyes. He knew how she was feeling. He could tell that she gained weight and why she gained weight at a certain particular time in her life, in her adolescent life. He is drawing those conclusions on a little bit of information and nothing but whatever John Mello is feeding him. So, what's their first thing? Aida's back with her mother. She, in May, begins living at Canebrake with her aunt, Tina Parcell, and that's where they're living there. John Mello's in Italy, and Zach Hughes and John Mello decide, well, you know what we're going to do? Let's embarrass Christina Parcell. Let's make her life look bad. Let's make her look like a prostitute. That'll help me get custody of her. That'll help me with the guardian ad litem. And so John Mello, according to Bevel, Detective Bevel, who testified, had photos, and according to the evidence right here, he had photos of Christina Parcell. And those photos were taken when she was much younger. And those photos are taken between two consensual adults engaging in what acts that two consensual adults can do. And that's it. And then he took those photos and he used them as a weapon. And he tried to make her look like a prostitute. Because that's what John Mello continually told Zach Hughes, according to his own testimony, Alex Field's affidavit. Let's make her look like a prostitute, and let's send them around to a neighborhood. Well, they sent them to a neighborhood where Brad Post lived. They didn't even send them to Canebrake. And we know this because in these WhatsApps, they talk about it specifically. They talk about, may I present to you my daughter's mother, Christina, Caroline Warren, escort. And we know there's a bunch of attachments that we can't see because Zach Hughes deleted these on October 13th. And when we retrieve them from WhatsApp, they're deleted. So you have to see us, investigators, department, manipulating these WhatsApps. And then they sent them that way, and then Zach Hughes receives them. He gets them, and he sees an email that was sent to him as well. This email is very important. And he prepares all these packages to Brad Post, to Mr. Bradley Post. These are all his P.O. Box. Brad Post. Cigar bar, where Brad Post hangs out. Misspells Mr. Post one time in the WhatsApps. Misspells it here, P-O-A-S-T, which is why we know it. But Zach Hughes admitted it. But this email here purports to come from Mullen Investigations. Mullen Investigations at protonmail.com. And it's cut out. And you've got this photo of Christina Parcell. You've got another photo of Christina Parcell back there, which is the same ones that are in here. But there's no URL with Belladonji on right here. And this is the escort site. And it says Caroline Warren. She became a member, Caroline Warren, in 2009. Well, this is 2021. And apparently this Mullen Investigations on May 16th found these photos attached to this website. Except the photos don't have anything attached to the website. It's just a square of an escort site of Caroline Warren. Well, I don't know who that is. I know this. I know Caroline Warren. I know Mullen Investigations, John Mello. Vanessa Carmelo testified to it. She received emails from Mullen Investigations. She received lots of emails from people purporting to be John Mello. So Zach Hughes went to the trouble of preparing all these envelopes, manipulating all the items, the photos, the escort, and putting it together. And he wanted to make sure we knew it was her. And so we would add a cover letter. You can see the cover letter that he would do. He had to add a cover letter to make sure you knew exactly who that was, that it was Christina Parcell that was engaging in prostitution. And he sent them out to shame her, to make fun of her. There's WhatsApps in there saying, we're going to ruin her day. And Zach Hughes did it the same way he committed this murder. He used his bike, he avoided cameras, tried to find a location, and he didn't know that we could track his phone. And so we know he was in Greenville when he mailed those in June and July, and he was in Tennessee when the other two were mailed. So we know he did all that, but the big point of the harassment is not that that's bad to do somebody. It's really what Tina Parcell referred to as revenge porn. South Carolina does not have a statute for revenge porn. We have harassment. And that's exactly what that is. But he's really doing it, one, to make her look bad, to make her look like a prostitute, but he's also trying to do it to gain a strategic advantage in this custody battle. And it doesn't work. He even sends one to the guardian ad litem. What does the guardian ad litem do? She investigates everything. But Brad Post put a lot of work in. Zach Hughes put a lot of work into that. It's a lot of work finding all those envelopes. To somebody he doesn't even know, he's never met, never talked to. Now, John Mello, I would say he's pretty much a liar. He dated Christina back in 05 and 06 and had their daughter in 2012, and of course this custody battle. And if you want to look about the character and who John Mello is, I refer you back to Vanessa Cormelow's testimony. She testified that John Mello would do horrific things in relation to this custody battle. To her. to a lawyer who's representing a little girl as a guardian ad litem who's practicing law for 26 years. He would accuse her of horrific things, according to her. He would accuse her of trafficking children in Spartanburg. He would post things on social media ridiculing her. And that's how John Mello operated. That's how he operated. He used deceit by using fake emails. He used threats to try to get what he wanted. Mullen investigation. He sent those to Vanessa Carmelo. He sent an email pertaining to be a lawyer named Sophia Carlucci, according to Vanessa Carmelo. And she knew it was John Mello writing it because she's read so many emails from him, they matched up. So he's trying to gain a strategic advantage. John Mello and Zach Hughes were trying to harm Christina because John Mello had a custody problem. And the only way to solve it was murder. So Zach visits John for 3 weeks in June in Italy. So he met him for 5 times between August and October 2020. They're having lots of conversations on the WhatsApp, and he's in 3 weeks in June in Italy. And it was a pretty important moment when Zach Hughes said, John Mello offered me $5,000 to kill Christina Parcell. John Mello offered me $10,000 to kill Christina Parcell. Now, of course, Zach said he wouldn't take that money. He would just do it for free. Because killing Christina Parcell is the right thing to do. So I submit that's when the plot to murder Christina Parcell began. That's kind of when this evolved. And I think they started with the photos, which were in June and July, but that wasn't going to carry any weight with anything. Interesting that a struggling pianist turned down $10,000. Do it for free. Especially of a person he's never met on behalf of a little girl he barely knows. Now, much of what Zach Hughes said, I believe, on that stand was true. I think a lot of it was a bunch of self-serving, narcissistic junk. Zach Hughes is trying to portray himself on that stand as a hero instead of the cold-blooded killer that he is. Ladies and gentlemen, we judge the defendant by their actions, not by their excuses or their words. Actions speak much louder than any self-serving lies from a sadistic, pathological killer like Zach Hughes. He murdered Christina Parcell, mother to Aida, sister to Tina Parcell, and daughter to Erica and Tim Parcell. Now, I've talked a lot about Vanessa Carmelo because she's a key witness, because that is the dispute that we're having, the custody battle. And she's in charge of making recommendations about who should get custody. Her job is to investigate the custodians. She stated that she investigated every allegation which were at Christina, which was involved in prostitution and drugs. She stated she would investigate every allegation, hire private investigators, put trackers on cars, meet with potential custodians, have home visits, and talk with the child constantly. So she's doing everything that she can possibly do. She even had allegations like Alex Fields. There's an affidavit that the defense submitted on Alex Fields, where he says that he was propositioned by Christina Parcell for sex and offered to sell him drugs. And he put in an affidavit. This was after John Mello put on Craigslist, you have any information about Christina Parcell that I know about? I'd like to know anything about. Who responds to a Craigslist ad about somebody and then sets an example of what they did at a bar? And for what purpose? Maybe it's true. Maybe it's not true. I have no idea. That's what Alex Field says. Really doesn't matter. While the defense wants to impugn the integrity of Christina Parcell as a justification for committing murder, so be it. If doing bad things means anyone can break into my house and stab me 35 times without retribution, then two things will happen. There'll be a lot of people stabbed to death, and I'll be out of a job, because all we'll have is vigilante justice in our system. But again, these are allegations that John Mello is making. He's looking for any dirt on Christina Parcell. Again, these are all allegations. Well, let's come to October. Vanessa Cormelo was getting close to making her decision. Who's going to get custody? Her investigation revealed that before Christina's murder, she would write a favorable report for Christina Parcell and a bad one. That's what Vanessa Cormelo said. In addition, it was almost 6 months since Aida had come home, and that's important. 6 months. Someone can file to terminate the parental rights of another. We were about to be 6 months. Zach Hughes said October was the time that he felt it was the time to kill her. Just felt it in his heart and his mind. And he tried on the 12th, did it on the 13th. That is important because it was getting close. John Mello's getting a bad report, and things aren't going to go his way, so he's got a problem. Now, if Christina Parcell is no longer around, he's the last man standing. He's going to get custody. So, Zach admittedly decides to murder Christina Parcell. That was his intent. He bought a gun and a knife about a month before. It was weighing on his soul. His custody dispute's not going well. And so he entered into a lot of planning going into this murder. A ton of planning. And the state presented all of this evidence to you before he testified. But we know that Zach Hughes on the 12th was up at the Mountain House because his phone showed that he was up there. And while up there, he had his truck. And we know he put his bike in the back of the truck. And we know he parked it somewhere. And we know that he decided to park somewhere near Canebrake and ride his bike in there. And we didn't know, but we know that he knew the schedule of Christina Parcell that day because he said John Mello told him. So he gets in his truck, and I would submit he arrives around 7:42-ish to somewhere wherever he parked. We never learned exactly where he parked near Canebrake, but we know he parked somewhere there, and he rode his bike. Because at 7:42, we know from his phone that he plugs it in and unlocks it. And that's the last activity on his phone at that time. So he parks, maybe he plans, he thinks, and he gets on his bike and he drives in. And we know he drives in because he passes Donna Gorman's house. And Donna Gorman was an early witness from the state. And she did an identification of Zach Hughes from that witness stand. State was not expecting that. We had never shown her a photo lineup. We had shown her a photo of the bike, of Zach on the bike from the ring cameras. But she had never seen Zach in person. And so we just left it. Now, we did wait until about 3 years after the murder before Donna Gorman told us that information. That is true. Riley Stokes talked to her that day, and he didn't have a copy of it. Master Deputy Wolf talked to her on the 19th, and he didn't show her a copy of the person on the bike. And so there was so much chaos going on, so many officers moving in so many directions, trying to find the evidence to solve this murder. It was just overlooked. And so when we went and talked to her, this was her testimony. And that's what we presented to this jury. She was right. She was right. The DNA proved it. Zach Hughes proved it. So Donna Gorman sees him, and she says this around 8:15-ish when he goes by. And then he goes to Christina Parcell's house. And my opinion is that he went and he hid under the bottom of the house. His testimony was different. He says different. He says that he got there and went straight in, dropped his bike, and went to the front door. We have a difference. Maybe he's telling the truth. Maybe I'm wrong. At the end of the day, it doesn't really matter. But I submit that he went and he waited. He had an hour to wait. Of course, he had an hour drive from the Mountain House all the way to Canebrake. You know what he could have done? He could have turned around. He could have done anything he wanted. He could have gone to the QT. He could have changed his mind. Had many opportunities to do that. He was committed. And so he went and he lied and he waited. And he waited for a time because he knew her schedule and he knew her car. He knew her address. That's in evidence. And he went and he decided to walk in the front door with roses as a ruse, according to his testimony, with a gun and a knife and a backpack, paint thinner so he could clean up afterwards, and he kills her. So let's see the moments before Christina Parcell is murdered. Zach Hughes, dressed as he said he was, gray sweatshirt, backpack, black pants, walks directly into that house. I can't see if he's carrying flowers. I know he had flowers on him. And he walks in and he surprises Christina Parcell. Points a gun at her and hits her in the head with the gun. And then he stabs, and he begins to stab, and he begins to slash, and he begins to slash, and he begins to stab, and slash. Now think of the force needed to stab someone in the chest, stabbed him in the back, all over the head. And finally, and through all the fighting, and the stabbing, and the pushing, while Christina is fighting for her life, he finds the vulnerable spots, stabs her in the jugular and the carotid artery, causing her to bleed out. With blunt force trauma to the head, she has to be on the ground. Blood is everywhere, pulling around her dropped phone and the couch. But that's not enough. He drags her through her own blood to cover up the crime as he closes the curtains and locks the front door so he's not detected, as droplets of blood fall from his blood-soaked clothes. She remains laying on that floor in her own blood with nothing but her blood-soaked scrubs and her wedding band that Brad Post gave her. his sadistic actions are not over. I submit, ladies and gentlemen, those rose petals had a dual purpose. He may have used them as a ruse to get in and get inside the house so he could surprise Christina and gain that strategic advantage to murder her. But he also sprinkled them around. He sprinkled them around the house, on her purse, around, as some sort of sadistic, artistic sign that he thought was necessary. Then he had to keep in line with the allegations: prostitution and drugs. Put a bag of cocaine under a couch or in a chair right down from her body. Killing her wasn't enough. Shaming her was the goal too. This was not to save Aida. This was to help John Mello win his custody case. He never told us about the drugs either. Never mentioned those. So then the cover-up. So then, after you effectuate the crime, you commit it, then you got to clean up. You got to cover up. So, you first had to cover up the scene. You had to worry about that DNA under her fingers. That DNA is key to this case. You had to wipe her fingers down with that paint thinner. He did not want to get caught. Pre-planned, and then really good exit strategy, cover up. Then he went back to the mountain house. Of course, we know he's there because his phone puts him there around 1:17. He connects to the Wynn Wi-Fi. The Wynns have a mountain house. He has access to it. Remember, it's real remote. I think Master Deputy Wolf said it's so remote you could walk around naked. Nobody would see you. Perfect place to clean up a crime scene like that. Can you imagine how soaked in blood his clothes were? Can you imagine how soaked in blood his car was? Can you imagine how soaked in blood his bike was? And he did. And he admitted it. Burned his clothes, ditched the knife and the gun in some pond, cleaned up everything, and he went back to Tyndall about his daily life. And that's what he said. Now, I've mentioned Zach Hughes' testimony a lot. And I'm sorry that you had the unfortunate privilege of hearing the specific testimony of the killing of Christina Parcell by a cold-blooded, cold stone-faced killer trying to portray himself as a hero instead of the cold-blooded, calculating killer that he actually is. Only a person with a severely diminished sense of heroism, with a heart that is cold as ice, can portray that. The absurdity of many of his words and I'll reference a couple. I wanted to make her death quick and painless. This is what he said. When I was listening to that, it was hard for me to comprehend that someone is actually saying that at their trial to a jury. Do we say thank you? I appreciate it. Thank you for taking my pain into consideration as you murder me? What does that even mean? Well, I ask you this. Was it quick and painless when he hit her in the head with a gun? Was it quick and painless when he stabbed her the first time quick and painless when he stabbed her the second time? How about the 5th? The 10th? Maybe the 20th? He was being considerate. Maybe the 30th? How about the final 35th blow? And then, of course, I asked him one question. How'd you drag her body across the room? And he said, I don't really recall, but I think it was by her ankles. And he looked me in the eyes in a stone cold faced way. Told me the answer. Like he was proud of it. He said, I do not want anyone else to be involved. I waited till everyone was gone. Thanks. Appreciate that. Talking like he's doing us a favor. I wonder what would happen if a neighbor did come over. I wonder what would happen if Brad Post had showed up. I wonder what would happen if Tina Parcell had showed up. Would it be a double homicide? So we could escape and escape detection? And of course, he was so calculated, he got her schedule that day from John Mello. And then he said, I didn't want to get caught because they would connect me to John Mello. Oh, okay. So if you didn't get caught, you've solved the custody problem. But if I did get caught, then I didn't solve the custody problem because then they would connect me to John Mello and he wouldn't get custody. Then he comes in here, testifies, connects John Mello. Doesn't make any sense. Now, he talked a good bit about his background. My understanding, he's a fantastic pianist, highly trained. But he went through his resume with an ego, letting you all know how great he really was. Military service. Playing these really difficult sonatas by Beethoven. I'm going to play all 16, never been done. But he described his sister Grace in great detail as well, for some reason. He said she was a horrific person when confronted with irrefutable evidence. She would go cold, stone-faced. She would manipulate and recruit others to do a terrible deed. If you trust Grace, you're only going to get hurt again. She was a vampire and would suck the blood right out of you. Maybe he's described himself. He said, I feel pity for her. He felt pity for Christina Parcell. How is that even possible of a human being? His heart is so mean, so depraved, that he viewed someone he'd never met and discussed the specific details of killing her, treating her like she was an elderly dog being sent to the vet to be euthanized. It doesn't get any meaner than that. Christina Parcell didn't have to die. Zach Hughes had a million opportunities to not do this. And if he did it to save Aida, million ways to handle that. Vigilante justice is not allowed in this state. Vigilante justice isn't allowed anywhere. Regardless of what Zach Hughes had in his mind or what he thinks he had into his heart, he's lying to himself. Because all he had was hate and meanness, coldness. He brutally murdered Christina Parcell. So, ladies and gentlemen, it's been a long 2 weeks. I thank you for your service, and I thank you for listening to me. The evidence is absolutely overwhelming. I'm going to ask you to go back there and deliberate. I'm going to ask you to find Zach Hughes guilty of harassment, of burglary, of possession of a weapon during the commission of a violent crime, and murder. Thank you.
May I please report? Let me get a little bit of water. I want to start with something that Mr. Wilkins said towards the beginning of his comments to you. He said, Zach Hughes solved John Mello's problems. Yesterday, Zach Hughes told you he solved Aida Mello's problems. That's what he told you yesterday. Ladies and gentlemen, you got to watch the state. You got to watch the evidence. Zach Hughes yesterday came in here and told you under oath that he killed Christina Parcell on October the 13th, 2021. He told you that. But contrary to what Mr. Wilkins just told you, killing somebody in and of itself is not a crime. Mr. Wilkins told you that he confessed to committing the crime. That is not the case. Yesterday, Zach Hughes told you that he killed Christina Parcell, but in doing that, he did not tell you or confess to any crime. And let me be clear, and let me tell you why I say that. Every crime, and the judge is going to tell you this in the instructions, every crime has two parts in general terms. The actus reus, which is the action, and the mens rea, which is what's in your mind, the intent that the state has to prove beyond a reasonable doubt. So it's very important that you understand this from the get-go. He did not confess to a crime yesterday. He confessed to killing Christina Parcell. But that in and of itself does not make him guilty of murder. That's very important. Okay? The first part of, or Mr. Wilkins had talked about how this case is unique. It is unique. And one of the unique parts about this case is that first part that I talked about, the actus reus, the action that's involved, there's very little dispute, if any. Zach admitted that he killed Christina Parcell, right? Where the dispute is, where the heart of this case is the evidence as to what was in Zach's heart, what was in Zach's mind, that the state must prove to you beyond a reasonable doubt. It must be evidence that leaves you firmly convinced. It must be evidence that would cause you not to hesitate to act. Right? That's what they have to do. So the heart of this whole case, Mr. Wilkinson can talk about the blood, he can talk about the scene, he can talk about all these things. But the heart of this case is the intent is the mens rea. What have they proven about Zach's intent? All right? Now, let's talk more about what the judge is going to charge on the law and what they have to prove about intent, about the mental side of this. All right? Zach has been charged with murder. The state must prove beyond a reasonable doubt malice. That is the intent, the knowledge, the mental part of murder. The state must also prove burglary in the first degree, that when he entered that home, he intended to commit a crime. In this case, murder. He intended to commit the crime, which means there was a crime he committed. For harassment, the state must prove that he sent those mailers, which he admitted to doing, he sent those mailers without a legitimate purpose. And for the conspiracy, the state must prove that he formed an agreement to do something illegal. That is the mental component to this. And again, that's the heart of the case. And Mr. Wilkins, in his opening statement, said, we have to prove the state beyond a reasonable doubt an angry heart, that Zach was mad. That's where the heart of this case is. What was Zach thinking? What has the state been able to prove beyond a reasonable doubt about what was in his heart and what was in his mind? Now, you're going to hear, the judge is going to talk to you about different types of evidence you can consider. He's going to talk to you about circumstantial evidence, which is evidence that an arrangement of facts, when put together, that lead to other facts or conclusions. That's circumstantial evidence. Judge is also going to tell you about direct evidence. Direct evidence is evidence that comes from people who perceived what happened, who with their senses derive knowledge about what happened. All right? That is direct evidence. The state has the burden of proof on the mental element, and the state is going to use circumstantial evidence. That's what they're going to use. We have no burden of proof whatsoever. We entered and are going to use both direct evidence and circumstantial evidence to explain what Zach's state of mind was on October the 13th, 2021. Now, what is the state going to do to try to prove what was in here, to try to establish the burden of the mental side? Again, it's more than just the acts. That's critically important. But what's the state going to use to prove the mental component to this? They're going to use the acts, and they're going to say, they're going to use the stab wounds, the photos. They're going to use all the actions that Zach testified to yesterday. That in and of itself is not a crime. And Mr. Wilkins, he talks about stab, and I wrote this down, stab, 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 slash. Right? Got to watch. Got to be careful, right? This is a tragic case. Bottom line, someone died. The last thing I ever want to do is minimize the tragedy in this case. Not going to do it. All right? But when we come to talk to you about what happened, you have to have faith that what we are saying is balanced. Think about what Zach testified to and what Claire Rose testified to about Christina Parcell and what happened that day. All right? Stab, 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 slash, slash, slash. Claire Rose testified Christina Parcell was 163 pounds. Zach testified that he was 160 pounds. Claire Rose testified that there were, of the 35 wounds, the vast majority were incised wounds. Superficial wounds, wounds that would have been consistent with a struggle. Zach told you that when he went inside, there was a struggle. He told you that they fell to the floor. He told you that when he got inside, his body would not do what he was telling it to do because he didn't want to do it. He did not want to have to do it. So let's talk about the circumstantial evidence that the state has offered as evidence to try to get you to understand what was in Zach's mind. The state talks about, and in determining how much weight to give to their representations about their conclusions on the circumstantial evidence, just think about this. Donna Gorman testified that 3 years after this happened, having never been shown a photo lineup, with Zach's face all over the television and the internet, that she says that she saw Zach. Now, here's what is most troublesome about this whole thing. She testified that she saw Zach at 8:15. That's what she testified to. She testified she saw Zach through 2 trees in her house, that he was wearing a hoodie, no evidence other than what she said about a hoodie. In fact, Zach said that he was wearing a hat, or a smaller hat. There is no way that she could have seen Zach Hughes at 8:15, because by the state's own evidence, with the ring cameras, with investigator Sparkman, the state's own evidence, Zach didn't even get there until after 9 o'clock. So when he says, Donna Gorman, she saw him, it's impossible that she saw him the way she said, because she said 8:15. By their own admission, by their own evidence, Zach didn't even get there until after 9 o'clock. Think about that. In determining how much weight to give to their spin on the circumstantial evidence, think about investigator Sparkman, right? Called him as a witness and showed him reams of WhatsApp messages. These messages were garbled, but he had a unique skill. I don't know if he went to WhatsApp school, but he spoke fluent WhatsApp, right? And he was asked to decode all of these messages for you as though you couldn't have done it yourself. But what's the most interesting thing about what he said in the WhatsApp messages, there was one message that he was not able to decode, coincidentally. The message that had the words Aida and doomed. That was the only message he could not uncode for some reason. Think about that. In trying to determine how much weight to assign to the state's conclusions or their spin on the evidence, think about Vanessa Cormelo and what she testified to. Mr. Wilkins talked about how she was doing everything she could during this period to uncover it. Really interesting, and the judge is going to tell you this. You can determine or decide how much weight to give to testimony. You can give it a lot of weight, you can give it a little weight, you can give it no weight. I want you to think about how much weight to assign to the state's conclusions and that testimony, because I want to take you to one specific exchange between Jake Hofferth and Vanessa Cormelo. Jake Hofferth asked Ms. Cormelo, prior to October the 13th, 2021, and he said this, and they've said this throughout this entire case, prior to the murder of Christina Parcell, which is for you to decide and you to decide alone. Prior to October 13th, 2021, did you have a recommendation as to where Aida Mello should live? In other words, would you have had a recommendation as to whether or not she lived with her mother? And what was Vanessa Cormelo's answer to that? And you can hear this for yourself. At the time, I would have recommended the mom. At the time. There was no follow-up to talk about other times. Can you trust that evidence? Very important. That's the circumstantial evidence. Now, let's talk about the direct evidence that you received from Zach himself as to why he did what he did. He got on that stand, he told you. Let's talk about the direct evidence. He talked about what he knew. What he was told by John Mello. That was part of it. He talked about that. But contrary to what Mr. Wilkins said, he had a lot of other information besides just what John Mello told him. He had a deposition that Christina Parcell gave under oath in July of 2016. And you remember I asked him, after you read that deposition, what did you believe about Christina Parcell? What did you believe? He said he believed that she was engaged in prostitution. He said he believed that she had participated in a pornographic movie. He said that he believed that she had used drugs after reading that deposition. Another document that Zach got, Alex Field's affidavit. Now, this is very important to consider about this. This entire case, the state has worked very hard to distance Christina Parcell from the escort website. And they've made these conclusions just because they want to. Despite the fact that there are website addresses on those photographs, they have insisted that those photographs were private photographs, were taken by John Mello and then somehow put on the internet by John Mello, that she had nothing to do with that, right? Think about this. And this is an evidence for you to consider. The Alex Fields affidavit, it has one page on the front, which is what he said, that they met randomly at Hall's in 2018, that she propositioned him for sex and drugs in exchange for money. He turned that down. But in the second page of the affidavit for Alex Fields, John Mello, in that advertisement, said, if you know this woman, her name is Christina Parcell, and then he puts the Caroline Warren alias in that ad. Right? Here's the question for you to consider. If he didn't think that she really and truly went by Caroline Warren online, why would he put Caroline Warren's name in an ad for people to respond to? Why would he include that if he did not think that may trigger someone who had seen her site? Why would he do that? I would submit to you, he put her name on that ad because she was Caroline Warren, and he was hopeful that someone who had seen the ad or used the ad would recognize the picture and contact him. That's the only reason why that makes sense. Let's talk about the other evidence, and let's talk about the elephant in the room. Let's just talk about that Mr. Wilkins discussed. The planning, right? Let's talk about that. Zach was very honest when he testified about the planning. He told you in detail what he did. In a lot of cases, planning can be good evidence. In a lot of cases. As Mr. Wilkins said, this is a very unique case. And probably one of the most unique aspects about this case is that the person who Zach believed posed the danger was the mother to her own child. Think about that. This isn't where you're home and an intruder comes in, you don't know, and it's a spur of the moment. This isn't a random interaction or difficulty. This is what Zach believed. This is a mother, the person who's charged with caring for your child, most importantly. The person of all on the whole planet who is supposed to be the most nurturing. This is the person who is doing this to the child. The person who lives with the child, the evidence was the person who shared a room with the child, the person who's with the child all the time. So in a situation like that, where you have a belief that's grounded on documents, that's grounded on information shared with you over many, many months, when you have that belief, how do you alleviate that threat, the threat from the mom, without thinking through how to do it? How how do you do that? And so I would submit to you, ladies and gentlemen, that the planning in this case, unlike most any other case, doesn't show malice because the mom was the threat. The mom was the one who posed the danger. Mr. Wilkins talked a lot about, this was just interjecting in the custody, just get John custody, get him custody, right? If this was all about the custody, why would Zach have waited so long to do it? Right? Part of it, he was in a process. Part of it, he was working on this music project. But the other part is, Aida and John were separated for half a year. Right? If Zach wanted to fix it to solve John's problem, he would have done it much sooner. But the reason why it took so long is that Zach agonized over it. What do I do? Over time, he continued to get information. What do I do? He didn't want to do it. If he wanted to do it, he would have done it right away. And he told you that when he testified. He told you in detail about that day. He told you about it. About when he woke up, he drove to that location and he thought he was going to throw up. He told you about his hand shaking. He told you about when he got out and got on his bike, it was one pedal in front of the other, just trying to make it there. He told you about this. And you saw him testify. He's, contrary to what Mr. Wilkins said, he doesn't think he's a hero. He's never asked that. He did what he believed he had to do to save an innocent child. That's what he did. That's why it's more than just the action. He hasn't confessed to any crime. He told you what he did. And he told you the truth about what he did. If Mr. Wilkins talked about solving John's problem, right? And he intimated in his closing that an aspiring or starving, I can't remember what word he used, pianist would turn down $10,000. Interesting. As though to say he didn't turn it down. There's no evidence anywhere that John Mello ever paid him a dime to do this. None. Gotta watch the state, ladies and gentlemen. Lot of in the state's closing, lot of moral indignation. That, what do you mean try to be humane? Who can say that? How does that even mean, right? I was not in Zach's shoes. Nobody was in Zach's shoes but Zach. Nobody was. None of us has been in a circumstance where we have reason to believe an innocent child is being abused by her own mother, where her father is out of the country, the evidence is shown, with a warrant pending, can't come back. When you write an affidavit to try to put the authorities on notice as to what you believe is happening, when you call DSS and DSS does nothing, none of us have been presented with that circumstance. Mr. Wilkins said, we can't condone vigilante justice. That's what he said. He said, if you find him not guilty, I'm going to be out of a job. Right? It's really interesting. The state wants you to be a legislature and make decisions for the people of the state in law and order. But they don't want you to be a jury when it comes to deciding how the law applies to the facts. Because they just want you to assume he's already confessed to it, he's guilty of a crime. They use the word murder throughout, which is a legal phrase, which is an offense that you have to find. So they want you to speak for the people of the whole state, but they don't want you to really look at the evidence. And that's what we're asking for. That's just what we're asking for. Mr. Wilkins said he could have done other things. This didn't have to happen, okay? The judge will not instruct you that Zach Hughes had a burden to exhaust all remedies, to try everything he could to do. He tried a lot. He wrote the affidavit, went to DSS, did a lot of different things. But there's absolutely no requirement. We have no burden whatsoever. Just to continue to remind you that. We have no burden whatsoever. The burden is on the state. And there's no burden whatsoever for me as Zach Hughes' representative to try to prove to you that he exhausted every remedy. That's just not what the law says, and you don't need to prove. You don't need to even consider that. The evidence is that Zach tried. And when everything failed, that's when he acted to do what he thought was right, and that is, and was, to save Aida Mello. Ladies and gentlemen, the state talked about the mailers, and I don't envy your task. I don't at all. It's a tall task. But I do think the mailers, this piece of the case is a little bit easier for you to resolve, and let me tell you why. The judge is going to tell you that for it to be harassment, a couple things have to happen. First, the person who was the target of the harassment, in this case Christina Parcell, who's alleged in the indictment, the state must prove beyond a reasonable doubt that she actually suffered mental distress, and that a reasonable person would have done so in that circumstance. But there has to be evidence that she actually suffered distress, mental distress. There is almost zero evidence that she actually experienced mental distress in this case, right? Let me talk more about that in specifics. There were at least 3 people who testified for the state who were with her when she gave the letters, those envelopes to law enforcement. At least 3 people: Brad Post, Dan Bevel, Mike Nicholson. Did any of those people testify that she was remotely upset? Any of those people say that she cried? Any of those people say that she was shaking? Any of those people say that she had made statements that led them to believe she was upset? Zero evidence that shows, or that even comes close to proving, that Christina Parcell was upset. And if anything, the evidence you've seen that has been introduced with nude photos of Christina Parcell online, with Alex Fields' affidavit, I think the evidence shows took a lot to get her upset or be in mental distress. So I would submit to you, ladies and gentlemen, on the harassment charge, that's something that you could go to initially and think about that evidence. And based on your recollection of the evidence, if you find that there's no evidence to prove beyond a reasonable doubt that she was in mental distress, then that's your answer on that charge right there. It's the state's burden of proof on each and every element. Ladies and gentlemen, in conclusion, the state has brought us here. And they've brought the charges that you are to consider. They've decided what to charge, and they have brought us here on these specific charges. And the charge they brought, specifically the charge of murder, is among the most serious charges there is. Doesn't get any more serious than that. Murder, the charge of murder, in contrast to what the state's position is, requires more than the act of killing another person. It requires malice. Malice is defined, and the judge is going to define this for you, as evil, as hatred. In his opening statement, Mr. Wilkins told you an angry heart, mad. Ladies and gentlemen, I would submit to you that the evidence in this case has failed to show you that you should be firmly convinced that Zach Hughes had hatred. You can be shown pictures and talked all about the acts, but when it comes to what he was thinking, what the evidence shows that was in his heart, that evidence hasn't come close. Ladies and gentlemen, in hindsight, 3 years after this happened, it's very fair for you to say this didn't happen, or this didn't have to happen, or disagree, I wouldn't have done that. Some of you may say you would have, some of you may say you wouldn't. That's fair. Bottom line. Can't say otherwise. But no matter what your take on what he did, I think it's so important that we rely on your common sense. And that was one of the things that Mr. Wilkins talked about early on, that how important your common sense is that you bring with you. And so in closing, I'm going to ask that you use your common sense that you brought with you to the courthouse and just ask yourself, does a person who kills another person with the intent to save an innocent child, does that person have evil in their heart? Does that person have an angry heart? Ladies and gentlemen, I would suggest to you that your common sense would tell you no. And that person who killed another to save an innocent child is not a murderer. I would ask that you return a not guilty verdict. Thank you very much.
Please, the court.
Now the state has an opportunity to rebut, and I promise you, ladies and gentlemen, I'm going to be brief, so y'all can get to your deliberations. I do want to address a couple of issues. I want to make very clear, in this record, there is zero evidence of any kind of abuse. Not for a witness, not from any evidence. Mr. Mormon said you got to have some emotional distress from the harassment charges. Christina Parcell had a bunch of neighbors receive pictures of her without clothes on, private photos between her and John Mello. And so what did she do? Immediately, Brad Post corralled them all up, took some from neighbors so they didn't see them, and she went to the police. Going to the police without emotional distress is not something that you see very often. Mr. Mormon talked about not trying to minimize this case. Minimize the killing of Christina Parcell. Minimizing the heinousness of this crime while trying to impugn her character he talked about malice. And he said that you got to have an angry heart. He kept referring to me. I said, an angry heart, malice. So you're mad at somebody. And I'll leave you with this. Ladies and gentlemen, in regards to an angry heart, just because Zachary Hughes' heart is so cold and so dead that it can't be angry, that is not a defense. You prove it by his actions. Thank you.
Members of the jury, it is now my duty as the trial judge to instruct you on the law applicable to this case. And in that regard, it is your duty as jurors to accept and apply the law as I'm now stated to you. Furthermore, it is your exclusive duty to decide all the issues of fact in this case and determine the effect, the value, the weight, and the truth of the evidence. All the parties have the right to expect that you will carefully consider and evaluate the evidence and apply the law of the case to it so that in the end, all parties will receive a fair and an impartial trial. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, it is my responsibility to preside over the trial of this case, and I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If there was any testimony ordered stricken from the record during this trial, you must disregard that testimony. And furthermore, you should not even mention or discuss any testimony that I've instructed you to disregard in the deliberation room. You are to consider only the testimony which has been presented from this witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law of this case, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I now tell you the law is, you must abandon this idea because you are sworn to accept the law and apply the law exactly as I state it to you. In every case tried in this court before a jury, the jury becomes the sole and exclusive judge of the facts in a case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you are not to infer from what I have said during this process or during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during this course of this instruction to you, that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. And as jurors, it is your duty to determine the effect, the value, the weight, and the truth of the evidence presented during this trial. The defendant is charged with the following: murder, possession of a weapon during the commission of a violent crime, burglary, first degree, conspiracy, and harassment, first degree. I remind you that the fact the defendant was arrested, charged, and indicted in this case is not evidence in this case and cannot be considered by you as evidence of guilt in this case, nor does it create any presumption or inference of guilt. These documents are simply the formal instruments which contain the charges made against the defendant. It is the formal documents by which this case is brought into this court. The indictments in this case allege several different offenses against the defendant. Each indictment charges a separate and distinct offense, and you must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant has pled not guilty to these indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until and unless you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory, and it is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you're firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there's a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find him not guilty. Facts and circumstance that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the accused. Facts in issue may be proved either by direct evidence or indirect evidence or circumstantial evidence. It is direct evidence if it proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. Direct evidence is basically evidence you can see, observe, or hear with your senses. Circumstantial evidence means the proof of a chain of facts and circumstances indicating the existence of a fact. In other words, you may infer that a particular event occurred based on proof of circumstances warranting such an inference. It is not something that one observes, but from facts, one can draw a conclusion. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. The burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The following things are not evidence, and you must not consider them as evidence in deciding the facts of this case. 1, statements and arguments of the attorneys. 2, questions and objections of the attorney. And 3, testimony that I instruct you to disregard. While argument of counsel is a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting arguments, counsel often refer to evidence. However, you should base your verdict on the evidence as you remember it. Therefore, if there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely upon your own understanding of the evidence. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. It becomes your duty as jurors to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, any bias, prejudice, or other motive in this case. You may also consider the appearance and manner of a witness while on the witness stand. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions, and an exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it's not contradicted. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. It is up for you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the weight you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt, and criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. And this is how you make a determination of whether or not the elements requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice, aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either express or inferred, and these terms express and inferred do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. The defendant is charged with possession of a weapon during the commission of a violent crime, and the state must prove beyond a reasonable doubt that the defendant was in possession of a firearm or knife during the commission of a violent crime. A firearm means any machine gun, automatic rifle, revolver, pistol, or any weapon which is designed to or may be readily converted to expel a projectile. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. The defendant is also charged with first-degree burglary. The state must first prove beyond a reasonable doubt that the defendant entered a dwelling without consent. A dwelling is any building or portion of a building in which a person ordinarily sleeps. A building is a dwelling even if the residents are temporarily absent from the building. In order to prove that the defendant entered the dwelling, the state does not have to show that the defendant's entire body entered the dwelling. The smallest entry is sufficient. It may be any part of the body, such as a hand or foot, or even an instrument, such as a hook or other instrument. In addition, the state does not have to prove that force was used to gain entry. If a person enters a building by using deception, artifice, trick, or misrepresentation to get consent to enter, this is an entry without consent. Next, the state must prove beyond a reasonable doubt that the defendant intended to commit a crime, either a felony or a misdemeanor, at the time of the entry. The mere entry into a dwelling without consent is not burglary. If the intent to commit a crime is formed after the entry, it is not burglary. On the other hand, if the defendant intended to commit a crime at the time of the entry, it is a burglary even if the intent was abandoned after the entry. It does not matter that the intended crime was not completed. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. Finally, the state must prove beyond a reasonable doubt the existence of one of the following aggravating circumstances, such as 1, when entering while in the dwelling or in immediate flight, the defendant or an accomplice caused physical injury to anyone not participating in the crime, or 2, when entering while in the dwelling or in immediate flight, the defendant or an accomplice used or threatened to use a dangerous object, or 3, when entering while in the dwelling or in immediate flight, the defendant or an accomplice displayed what was or appeared to be a knife, pistol, revolver, rifle, shotgun, machine gun, or other firearm, or 4, when entering while in the dwelling or in the immediate flight, the defendant or an accomplice was armed with a deadly weapon or explosive. A deadly weapon is any article, instrument, or substance which is likely to cause death or great bodily harm. Whether an instrument has been used as a deadly weapon depends on the facts and the circumstances of each case. The following are examples of instruments which may be deadly weapons: a pistol, a shotgun, a rifle, a dirk, a dagger, a knife, a slingshot, metal knuckles, a razor, gasoline, a firebomb, Molotov cocktail, and lighter fluid. A gun may be a deadly weapon. even if it is not operating. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the person hold a meeting and expressly state in the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1, following the targeted person as the targeted person moved from location to location, 2, initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted, 3, surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person, or 4, committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of the targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including, but not limited to, a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. In determining the guilt or innocence of the defendant, you cannot consider any possible penalty for any particular crime. The punishment for the crimes is a matter for me to determine and should never be considered by you in any way whatsoever in arriving at an impartial verdict as to the guilt or innocence of the defendant. Madam Foreperson and ladies and gentlemen of the jury, I wish to express the hope that each of you will be mindful of the importance of your responsibility. You're not called upon to serve as jurors very often, and the proper performance of the duty requires each of you to reach the height of freeing your mind of all improper influences. As the presiding officer of this court, I am vitally concerned that whatever verdict you find will be the result of your going into the jury room and confining your consideration to the evidence and the law that you have heard in this courtroom, weighing it fairly and impartially, as I have every confidence you will do. Your verdict in this case cannot be based on sympathy, compassion, prejudice, or emotion, or some other consideration not found in the evidence. Remember, your verdict must be unanimous. I will now explain the verdict form and possible verdicts. There are 2 pages to the verdict form, and this will go back with you to your jury room. Once you have received that, you'll be instructed at that point to begin deliberation. There are 2 possible verdicts for each charge, which you may find in this case, and there's no significance whatsoever in the order in which I state these possible verdicts. It is simply that one must be stated first. Ladies and gentlemen, your verdict must be a unanimous one. Madam Foreperson, when the jury agrees on the verdict, you will write the verdict on this verdict form and then sign your name as Foreperson. Then knock on the jury room door and inform the bailiff that you have reached a verdict. At that time, we will receive you back into the courtroom. Madam Foreperson, if the jury has any questions, please write the questions on a piece of paper, not the verdict form, and give to the bailiff. Everyone needs to be present when deliberating. If one of you takes a restroom break, then the rest of you should pause deliberations until said person returns. I ask that you now return to your jury room, but do not begin deliberations until you are told by the clerk or the bailiff to do so. There are matters that I must discuss with the attorneys before you begin your deliberations, and if my 4 alternates will remain in the courtroom.